name's Andy Belwest. I've been working actively with Move On for about a year. I've been receiving their emails since they started in 2000. But I've really been enjoying the past year, getting to meet a lot of great people, such as yourselves. But an issue of the past couple of weeks, so we welcome you to look around, find a rally, and go there, because when our government is focused on something, it's good to see it through as quickly as possible. It is because of the Supreme Court decision in January, where they decided, I mean, I'm going to say it in a couple of words, and these guys are going to give us some better details, that corporations are people and that money is free speech. So that is obviously a problem if we want a democracy where there is equal participation and equal access to the policy making that's done by our Congress and the government in general. Just a quick poll here. Obviously, we just finished up with healthcare, and didn't really finish, but we got some progress there. Can we see a raise of hands if you took any action? That was going on for about a year, right? And it took a lot of effort by a lot of us. We're going to have Q&A. Then we're going to break up into discussion groups, because action can happen even here today. We can make some good progress on how to reach out to more members, grow our membership, reach out to the media, make sure they get here, make sure we get on TV and the internet. It is we're advocating for. So I'll discuss those groups a little bit more in a minute. Today we have John Bonifaz and Danny Schechter, and John's going to talk first. Just by way of introduction, I hope we do this right. John Bonifaz is the legal director of VoterAction. He's been with that for about 2 years. Before that, for many years, he was with National Voting Rights Institute, NVRI, which he founded in 1994. He grew that. And that was working to protect the rights of all citizens to vote and participate in the electoral process in an equal and meaningful basis. Well, that pretty much says why we're here today. So without further ado, John Bonifaz.
Panel with Danny Schechter. He is a brilliant filmmaker, a brilliant strategist, and I'm pleased to be speaking here and going before him, because you're going to have a treat today in hearing from him. I want to first start out and talk about the Citizens United ruling, what the court decided, and then what we as a people can do to respond. But before doing that, I'd like to just take a survey of the room. If you are a corporation, will you please stand? Any corporations here? Person, would you please stand? I think this highlights a clear distinction. Corporations do not send representatives, but they are not people. They do not have qualities like you and I. In fact, they are given state-based advantages that you and I do not have. Limited liability, perpetual life, the ability to aggregate wealth and distribute wealth. And because of that, we as a society for over a century have recognized that we can place proper restrictions on corporations, that we can rein them in with respect to the political process. Since 1907, during the Teddy Roosevelt era, we have barred corporations from giving directly to candidate campaigns. And for over a century, we have recognized that corporate political spending in our political process has no place until now, until this ruling in Citizens United v. FEC. January 21st of this year, the United States Supreme Court swept away that century of precedent and said that corporations can be treated as people with free speech rights in the political process, that they too can engage in participating in our politics and spending their general treasury funds. We as people do not have general treasury funds. We don't have that kind of access to funds. And when we're talking about the top Fortune 100 companies, think about this. In 2008 alone, the top Fortune 100 companies in this country made $600 billion in profits. Now, let's talk about the kind of money that was spent in 2008 in the presidential campaigns, Obama and McCain campaigns and others combined, congressional campaigns combined. The overall amount of money was $5 billion. An enormous sum of money to be spent on our politics. But if the Fortune 100 companies could have spent less than 2% of their general treasury funds in 2008, they would have more than doubled the total amount of money spent by all those campaigns combined. McCain, Obama, all the congressional campaigns combined. That is the direct threat posed by this ruling to our democracy and to the integrity of our elections. They now have the ability, corporations, particularly these very large corporations, to come in and change the landscape of our politics. And they also have an ability to exact a psychological impact on our politics, because now every elected official at the federal level, state level, local level will need to think again when they go after a corporate interest. They're going to know that if they go after a corporate interest on behalf of the public interest, they may get targeted by XYZ corporations. And that is a fundamental danger to our elections. Now, what was the court doing with this case? I think it's critical to understand that this case, Citizens United v. FEC, was not originally set up to address the question of whether this century-old precedent should be overturned. In fact, it was about a movie called Hillary the Movie, created by a Virginia conservative advocacy group called Citizens United. They put together this movie during the presidential primary season in 2008, designed to attack then presidential candidate Hillary Clinton. They had some ads that went with the movie. And they set it all up because they wanted to challenge a provision of the Bipartisan Campaign Reform Act passed in 2002, known also as the McCain-Feingold Law. They wanted to challenge that provision in court as being unconstitutional, and that provision barred corporate advertising 60 days prior to an election. That's why they did this movie. That's why they set up this case. And in fact, in the spring of 2009, they argued before the court solely that this provision should be struck down as unconstitutional. Then a 5-justice majority decided to do something different with this case.